Hello, YouTube. I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We had a Zoom call with a very clever sound engineer today, which I'm very excited about. Tell me if things are better. So we're going through a process of elimination. This is the first step, and then each day that goes by, if the video doesn't improve in terms of getting rid of that static in the background, we're going to be doing additional things. There's a lot of things we can. We play with a lot of settings today, and the next step is going to be moving some wires around, and then after that, we'll be looking at some kind of microphone amplifier situation. So there's a lot. But it's exciting because we got to get the sound ironed out for you. You deserve it. Gosh darn it, you're worth it. All right, we got a question from YouTube user Child of Captivity. That is quite a username. I hope that you are okay. And Child of Captivity says, I am suing a big company and my lawyer says that they have a waiver. They have 60 days to reply. What does that mean what does it mean when they have a waiver? Okay. So when you file a case, when you file a lawsuit, generally in most of the country, you can either choose to serve it, right? Process servers, you've heard of this, where somebody goes out and serves the party that's being sued because they have a right to know, right? You can't just sue someone and be like, they didn't respond, so I win. So you actually have to make sure they know, right? But process servers are expensive and inefficient and like waste the court's time and resources and create drama. The whole thing is kind of silly. So in most jurisdictions, what you can do is, especially when somebody's represented, you can send them a waiver of service. It's called different things in different places. It works slightly differently in different places as well. So like giving you a general description here, but check your local laws, check with local counsel. And the idea behind a waiver of service is usually as follows. Hey, if you accept service by mail through your attorney, you'll save a little bit of money and you'll have extra time to answer. Sometimes it's like 120 days instead of like 60 days, whatever it is to answer, right? And so that's the idea behind a waiver of service. Now, the other side, the defendants to be, they don't have to agree to the waiver of service. They can say, no, we don't agree to waivers. We decline the waivers. You must go ahead and serve us. And then there's a whole bunch of ways that service can be effectuated, depending where you are, depending on the rules, depending on if it's a business or an individual, right? There's different things. Businesses can generally just be served at the place of business, and that's good enough. Excuse me. Individuals, sometimes you actually have to serve the person in person. So you have to actually find them, catch them in the jurisdiction, and then effectuate service. In some jurisdictions, you can do what's called nail and mail, meaning you can just nail it to their front door or like a door where they should receive it and mail a copy. There's service by publications sometimes where you're filing. I mean, you're essentially like publicizing. You're like putting service in. I mean, this is ancient, but in print publications in the hopes that someone will see it. And that's a potential form of service as well. So you can kind of see the history of process service is storied and long and wildly inefficient and silly and filled with drama. So that's why now today we have what's called the waivers of service. And I'll be honest with you, I think it's less than 5% of our cases have to actually be served. Excuse me. It's pretty rare that a defendant will pass up on the extra time. The savings are minor. It's like $100 or whatever it is. And that's different in different places. But the extra time is pretty valuable, right? Because a lot of times defendants don't have the attorney they're going to want to hire to defend this case, right? They have their in-house counsel or whoever it might be. But generally, you're going to want to hire specialized counsel to defend a case in this field, in the field of employment law, employment discrimination, employment sexual harassment. So it takes time to interview those attorneys. It takes time to negotiate those retainers because they're quite sizable and expensive. And it also takes time to draft an answer and for the defense counsel to get their arms around the case and to start advising people as to what they should and should not be doing as the case goes forward. All of that is very time consuming. And so the extra time that a defendant gets with a waiver of service can be invaluable. No question. Now, sounds like your lawyer is granting 60 days for the waiver. And then at the end of the 60 days, you're going to, if you haven't received a response, you're going to go ahead and hire a process server. Depending on how expenses are being handled on your case, you might get a bill for that process server, or your lawyer might front the expenses for the process server and then recoup it later, or your lawyer might just pay for the process server. I don't know. I don't know what your arrangement is. I don't know what the rules are, where you are, but those are the ways it could go down. Generally speaking, it's better for everyone if the waivers go through. There's a common misconception in plaintiff side clients. They're like, oh no, I want them to be embarrassed by the process server. It's not really a thing. And also, frankly, if your demand letter went in correctly, they probably were embarrassed anyways, because it probably went in email, hard copy, fax. Listen, when it goes in hard copy and fax, like all the support personnel at the entire company are going to see it, right? So that it's already a buzz, right? People are talking about it. That's the drama moment. The like idea that your employer is going to be like slipping away from the golf club or whatever, the shooting range, like, you know, like fancy British, like, I don't know, fox hunting range, whatever it is, so his friends don't see him get process served by a lawsuit. None of that's going to happen. None of that's a matter. And also, if that was something your employer was worried about, they would have accepted the waiver. So that dream of like embarrassing your employer, it's generally not a thing. Like, nobody cares. People get sued all the time. Process service is just something that like somebody's like, aha, I got you. And the person receiving process is like, okay, that's fine. Hi, right? So like it is a recurring theme in this industry though, where people are like, no, I don't want you to do waivers. I want you to hire a process server and make them miserable. And it's like, yeah, that's not going to happen. There's a lot of ways to make a defendant miserable. That's not one of them. That's just being a little bit dumb and a little bit silly and a little bit wasteful and inefficient. It does not really create any extra pain and suffering for the defendant. Listen, you're litigating a case, you're not trying to create pain and suffering, but a little extra twist of the knife, never hurts. I agree with that general sentiment, but this is not the way to achieve that. Trust me. Anyways, I hope this sounded slightly better today. Child of captivity, I hope all is well. I wish you great success with your case. It sounds like your lawyers got your case moving, which is positive. If this video was helpful, like, subscribe, comment down below. It helps our channel to grow, and I hope you all take care out there. And let me know how this sounded. Comment below. Take care.